Senator Chris Van Hollen and Governor Kristi Noem walked into that hearing room with completely different missions, but nobody expected the clash that followed to expose a far bigger question than either of them admitted out loud. It wasn't just about one man, one case, or one agency. What happened in those first few moments was a warning sign about how fragile the rule of law becomes when a government official refuses to answer a question so basic, so direct, and so non-negotiable that every viewer watching could feel the tension build before a single voice even rose.
Senator Van Hollen.
Thank you, Madam Chairman. Madam Secretary, it's good to see you.
Good to see you too.
And I was glad to see in your recent testimony that you reaffirmed your obligations to uphold the Constitution of the United States. And I understand you had an exchange with Senator Murphy on the Abrego-Garcia case. And so I'm just going to put the question directly to you. Are you or DHS doing anything to comply with the 9-0 Supreme Court order to facilitate his return to the United States? Just yes or no.
This administration is following all federal court orders.
Madam Secretary, this is a simple
question.
question.
It's the president's prerogative on conversations that
Madam
happen
Chair,
with the president of El Salvador.
I ask a simple question. We have a limited amount of time. I just asked you, Madam Secretary, whether or not you or the Department of Homeland Security are taking any action to facilitate the 9-0 Supreme Court decision to facilitate his return. This is a very simple question. Are you taking any action to facilitate his return, or are you not?
This administration is following and complying with all federal court orders
so,
to make sure that we
so
are...
you are, so because the court ordered that you facilitate his return, so you are facilitating his return.
Sir, Senator, thank you for the question, but what I would
Madam
tell you
Secretary,
is that we are following court orders,
Madam
and
Secretary,
that your advocacy for a known terrorist is alarming to me.
Madam Secretary,
it's alarming to me because he's a human smuggler.
Madam
he's
Secretary, I'm going to have to reclaim
and
my
a terrorist, and he's not a U.S. citizen. He's a citizen of El Salvador, and he's home. If he were to come back
Madam
here,
Secretary,
we would take him immediately.
All right,
back
I'm going to have
Salvador.
to, Madam Secretary, you should know a couple facts then, which is, number one, in 2019, the Immigration Court said that he should not be returned to El Salvador because it would put his life in danger. The Trump administration at the time did not appeal that decision. After that, he got a work permit and was working legally in the United States of America. This is also why the district court and the appellate court and the Supreme Court have ruled as they have. I suggest that rather than make these statements here, that you and the Trump administration make them in court under oath, because despite what you just said, the federal district court whose judge is hearing this case right now said, and I'm quoting, that the administration has provided no evidence linking Abrego-Garcia to MS-13 or any other terrorist activity. I'm not vouching for the man. I'm vouching for his due process rights.
Yes, you are, sir. You've
no,
been vouching
no,
for
Madam
him.
Secretary, with
I would
respect.
suggest that you defend and
Madam,
stand alongside the victims of illegal crime.
This is political rhetoric.
The citizens who live here and are United States Americans. I would suggest you advocate for them as hard
Madam
as you do
Secretary,
for foreign terrorists.
I know you're doing a political speech
No,
here.
I'm
I
not,
get it.
sir.
I'm asking questions of law. No, you're just spewing rhetoric.
I truly believe this.
Well,
truly
you're
believe
spewing
this
rhetoric.
as an American.
Let me ask you this: Do you agree with Justice Scalia in the Supreme Court opinion in Reno v. Flores that, I'm quoting, "It is well established that the Fifth Amendment entitles aliens to due process of law in deportation proceedings." End of quote.
Sir, we are utilizing every due process tool that this Congress has afforded us. The Congress decides what
Madam
due process
Secretary,
is appropriate for every situation. Expedited removal is a due process that you have afforded us that we are utilizing. The Alien Enemies Act
I'm going to
is another
reclaim my
tool that
time,
we're
Madam
utilizing.
Secretary.
So
You
we are
are,
giving due
Madam
process
Secretary.
and using the tools
Madam
that
Secretary,
this Congress has given us.
this is really, I'm asking sort of simple questions of law and simple questions like, are you complying with the 9-0 Supreme Court decision? And you seem to think that's some kind of trick question. Let me ask you this. You were down at CCOT in El Salvador, and you said, and that I'm quoting, "It is one of the tools in the toolkit that we will use." And it's well known that the Trump administration is paying the government of El Salvador to keep these individuals, including those who the U.S. courts have determined were illegally taken out of the country in violation of their due process rights. Have you seen the grant document between the United States and the government of El Salvador with respect to the CCOT?
It's important that everybody knows the consequences of what happens for their actions in this country. When you break the law and you're a member of a foreign
Madam
terrorist
Secretary, I asked you a
organization, there are
question. Have you
consequences
seen
to
the
that.
document? This is not hard.
Yes, I have.
Okay. And what are the provisions of the doc? So do you know what entities in El Salvador are
Sir,
receiving
I'm
the
sure
funds?
you can see this document as well and have looked at it for
I'm
evaluation.
glad you
as
raised
well.
that, Madam Secretary, because I sent you a letter along with many of my colleagues here on April 8th asking for, among other things, that document. Will you respond to the letter that we sent?
I will respond to your letter.
Can I get some sense of when?
We will take a look at it. I don't remember seeing your letter yet, but I will certainly
Well,
take a
it's
look
been
at
there
it
over a
and give
month.
you a
The
response.
senator's time has
No,
expired.
Madam Chair.
Senator Kennedy?
Madam Chair,
Madam
the
Secretary,
Secretary, I have some additional questions
No,
related
sir,
to
that's up
fire
to
cap.
you to manage that time. Senator Kennedy?
Madam
Well, I need a
Secretary,
little help from a chair that respects the members of the
Madam
committee. I'm sorry, Madam
Secretary.
Chair. This is
you pretty
The moment the senator leaned into his microphone, you could sense he wasn't there to posture. He came locked in with a question that no administration should struggle with. Are you following a unanimous Supreme Court order, yes or no? And when he asked it the first time, the room held its breath. When he asked it the second time, you could already tell something was deeply off. And by the third time it was clear this wasn't a misunderstanding, this was an official struggling to explain why a 9-0 ruling from the highest court in the country still didn't have a straight, transparent answer. This wasn't theater, it wasn't a performance, and it wasn't the senator trying to make noise. It was a constitutional stress test unfolding in real time. A unanimous Supreme Court ruling is not a suggestion, not an opinion, not a casual memo. It's the final word of the judicial branch. And yet here he was trying repeatedly to find out whether the executive branch was actually following it. The fact that the question even needed to be repeated showed that something was deeply out of alignment. And once you look at the man at the center of the entire battle, the stakes get even more intense. His name is Kilmar Abrego Garcia, and to understand why this exchange erupted, you have to understand what happened to him and what the courts have already said. Years before this hearing, Garcia faced the full weight of the government's deportation machinery. But something different happened in his case. An immigration court in 2019 ruled that sending him back to El Salvador could put his life in danger. They weren't speculating, they reviewed evidence, testimony, and legal standards and concluded he should not be deported. And here's the key, the government at that time did not appeal that ruling. The decision stood. Afterward, Garcia was issued a work permit and lived and worked legally in the United States. His life moved forward. Until the day it didn't. He was taken, removed, and sent back anyway, despite that court ruling. When the case went back into the legal system, every level of the judiciary, the district court, the appellate court, and finally the Supreme Court concluded that his removal was unlawful. That's why the 9-0 ruling exists. That ruling didn't come out of nowhere. It was the correction of a mistake that already shattered someone's life once. But the situation grew explosive not because of legal nuance but because of the accusation that came next. When Van Hollen pressed the simple question about compliance, Noem did not answer directly. Instead, she shifted into a completely different frame, suddenly describing Garcia as a terrorist and a threat. This wasn't a slip of the tongue, it was a deliberate reframing meant to distract from the legal issue and move the conversation into emotional territory where facts lose clarity. The moment she did it, the senator cut in with something the public rarely hears so plainly. The district court, under oath, on the record, said the administration had provided zero evidence tying Garcia to MS-13 or any terrorist activity. Zero, none, not one shred. That's not advocacy, that's the judge's own language. And this is where the clash became unavoidable. A legal question had become a rhetorical battlefield. Noem's framing suggested that following the Supreme Court's ruling would be some kind of security risk, while Van Hollen kept pulling the conversation back to the Constitution's most basic principle, due process. He wasn't defending the man, he was defending the law. A government doesn't get to label someone whatever it wants simply to avoid following a ruling. That's how rule of law cultures collapse into rule by exception. And once you let exceptions happen for the people you dislike, those exceptions eventually expand to everyone else. The more Van Hollen pushed, the clearer it became that Noem wasn't going to acknowledge the obligation directly. She kept repeating broad phrases, "We are following all federal court orders," without confirming whether DHS was taking the specific steps the Supreme Court mandated. And those steps matter. A return order is not symbolic. It requires logistical planning, coordination, and diplomatic engagement. It forces the government to correct an action that courts determined was unlawful. But when those steps remain vague or unspoken, you have to ask why. The human consequences behind all of this are enormous. When Garcia was sent back, he didn't just lose a case, he lost his job, his home, his life in the United States. People don't get deported into comfort. They often get returned into danger, instability, or situations where threats are not hypothetical. And courts recognized that risk in his case. That's why they ruled the removal unlawful. When a legal system acknowledges wrongdoing, the remedy is supposed to be meaningful. But if the executive branch won't even confirm whether it is carrying out the remedy, what does that say about accountability? And this isn't just one case. Immigration lawyers and policy experts have quietly raised alarms that this situation could set a precedent for ignoring court orders when inconvenient. Nobody is claiming it officially, but reports suggest that some insiders believe the government is slow-walking compliance to avoid political backlash or public attention. Again, these are rumors, not proven, not verified, but they circulate because the government's lack of transparency leaves space for speculation. When officials dodge direct questions, people naturally begin to wonder what's happening behind the scenes. That's why Van Hollen's next move became so important. He shifted from the case to the broader principle. He brought up Reno v. Flores, a landmark Supreme Court ruling establishing that non-citizens have Fifth Amendment due process rights in deportation proceedings. This wasn't a political point, it was a constitutional one. The government cannot remove someone without giving them a fair chance to challenge the basis of that removal, and when a court decides that the process was flawed, the government has to fix it. That's not optional. That's the architecture of separation of powers. But the tension didn't stop there. Van Hollen then pressed Noem on diplomatic documents between the United States and El Salvador, agreements that involved detaining individuals who were removed from the U.S. These agreements matter because returning someone from El Salvador to the U.S. requires cooperation. But when he asked whether she had seen the grant documents, she reluctantly admitted she had. And then when he asked what was in them, she deflected again. His response was sharp. He and several colleagues had sent her a formal letter requesting those documents weeks earlier, and they received nothing. Transparency isn't a courtesy, it's a requirement. Congress oversees executive agencies. When the agency refuses to answer, oversight collapses. And when oversight collapses, the public loses the ability to hold its government accountable. That's why this moment wasn't just about immigration, it was about whether agencies believe they are accountable to anyone at all. The hearing reached its most heated point when Noem again accused Van Hollen of advocating for a terrorist. It was a rhetorical grenade thrown into a legal argument. Watching him sit back, take a breath, and then calmly say he was advocating for due process, not for the man, was one of the clearest demonstrations of principle you will see in modern politics. He quoted court rulings. She offered labels. He pressed for constitutional clarity. She leaned on security theatrics that the courts had already dismissed. And this is where the deeper danger comes into view. When the executive branch uses emotionally loaded language to dismiss court rulings, it signals something more troubling than disagreement. It signals the belief that executive power outranks judicial authority. In a constitutional republic, no elected official has that authority. Not the president, not a cabinet secretary, not an agency. That's why a unanimous Supreme Court ruling carries so much weight. Every ideology on that bench agreed that the removal was unlawful. The courtroom and the hearing room are supposed to function differently. One interprets law, the other oversees those who enforce it. But in that hearing those worlds collided. Van Hollen wasn't asking a complicated question, he wasn't seeking privileged information. He wasn't probing national security operations, he asked for confirmation that the government was following a ruling the entire Supreme Court agreed on, and the inability or unwillingness to answer made everything else in the room heavier. For viewers watching, the question isn't whether you think Garcia is innocent or guilty, safe or dangerous, deserving or undeserving. The question is whether the government should be allowed to ignore or sidestep a court ruling simply by labeling the subject with whatever word makes compliance inconvenient. Once that door opens, it doesn't close easily. If due process can be bypassed for one person, it can be bypassed for anyone. And that's the true stakes of this hearing. It wasn't a political argument, it wasn't a partisan clash, it was a test of institutional integrity. When systems work, each branch checks the other. When systems fail, power begins to shift away from law and toward whichever official shouts their version of reality loudest. And in that moment, Van Hollen refused to let that happen. Whether you agree with him on policy or not, his insistence on a straight answer was a necessary pressure test for a system that depends on transparency to survive. As the hearing ended, the room felt unsettled, not because the argument was loud, but because the answer never came. And that silence spoke louder than any rhetoric. It left a question hanging in the air that every viewer needs to think about long after this video ends. If a government can ignore a unanimous Supreme Court ruling today, what prevents it from ignoring another tomorrow? If you found this breakdown important, make sure you hit subscribe, drop a comment with your thoughts, and share this video so more people can understand what's really at stake when institutions stop answering the simplest questions. The more people paying attention, the stronger our democracy becomes.